question is, when the given amendment of the certain European Union treaty, via which the rule of law became part of the primary law of the European Union and not only referred, for example, by the European Court of Justice, what was the situation? That is, what was the intention of the member states signing the treaty? Whether they recognize that this concept is different than the previously used national concept. Whether, for example, in the documents when the new treaty was elaborated, referred that that is something different that you previously knew about rule of law. I think it's elemental because nowadays we, in a given sense, accept that this is a national concept, this is an international concept. Okay, at the EU level we use an international concept. However, whether that was the first intention, an original intention of the member states. Sorry, that is the question. And or comment, who knows.
Maybe I can comment on your question with this statement, which is also the part of my paper, and it was one of the conclusion remark. In my opinion, this highlighting distinguish between international and the national concept of the rule of law, I think that it is, maybe I will say something which can be interpreted differently or wrongly, but I think that it is a kind of a historical mistake. The concept of the rule of law is the one concept. And in the opinions of the Venice Commission, and I'm also the member of the Venice Commission, and when I am not at the state mission, I have an obligation, at least moral and professional obligation, to stand to the position of the Venice Commission. There is no real distinction between the international and national. The Venice Commission is always talking about the rule of law. The checklist of the rule of law is the checklist of the rule of law. What rule of law? The European and international standards, which should be in a different mutatis mutandis and other different flexible ways, should be implemented and evaluated in the national countries. So I think that for the rule of law, which is definitely we know that the volumes was written about the concept of the rule of law since Dicey, the English constitutionalist from the 19th century, who said that legal certainty, judicial protection of human rights, and equality before the law are the three basic principles of the concept. That from that period, in theory, there were different concepts, but in practice, the rule of law is the rule of law on the terrain. The rule of law is always the rule of law in the practice, in the judicial decision of the courts. And as my young but experienced colleague from Romania said, the problem is that that distinction is has become during the times not only distinction but a struggle between two concepts. With practical effects in struggle between the courts of the different jurisdictions. I think that one of the most important remarks from the conferences like this should be that the concept of the rule of law is unique, and that distinction is not only vague, but I think that it is, as I said at the beginning, a kind of historical mistake, especially in the period when the Central and Eastern Europe was trying to become the EU members quickly, fastly, and with very small negative consequences. But when they enter into the EU, they realized, unfortunately, I can say because I am not coming from the member of the EU, I think that also the institutions, especially the legal institution of the EU, does not realize that this is the concept which if I can say, which maybe the right word is not force, but tries to find this unity between legal orders, not unity in a monotonic way, but unity in differences. And the concept of the unity in differences is also not new. It is the concept very old from the first federal state of America, which is based, all the legendary constitutional system is based on that formula. I think that the European Union is not, if I may say, ready to admit that this formula is the only formula for success of the rule of law in the European Union. And on the other side, as my colleague also said, the national authorities, especially courts, the Supreme Courts, the constitutional courts, have to stand on the very flexible position of interpretation, to understand that also the national constitutional identity is a phenomena which is not yet, if I can say, constitutionally, historically confirmed. It is just a period. We don't know in maybe 10 or 20 years if this concept will survive. But what is definitely true and what will survive, it's the concept of the rule of law as such, as an operative concept. And that is, of course, that is a phrase. But that is something that Venice Commission also says in the checklist of the rule of law and in other documents. They don't want to try to find a definition of the rule of law. And again, I highlight that they don't make a distinction between the international and national rule of law.
I would have maybe two comments on that. The first one is that I agree with you in terms of this intention of the member states. So the Lisbon Treaty was adopted after the enlargement of the 10 states in 2004. And I think, as I highlighted as well, that the European Commission has a major role in the 90s for the preparation, for more than almost 15 years or 14 years of the preparation of these states. And they did not indicate that there would be such a requirement, that this is explicitly that what the EU understands and what EU institutions, CGU, European Commission, etc., understands under the rule of law. And these countries joined the EU, and then even after the big enlargement, the CVM procedure mechanism was elaborated, and it was in 2014. And since that, the rule of law report, rule of law framework of the Commission, and since then, no member state joined. So they didn't pose this before the accession, but it serves, in my opinion, sort of a post-accession criteria evaluation of the Copenhagen criteria, for example. And my second comment would be also on the intention of the signatories of the Lisbon Treaty, so the states, that the Lisbon Treaty also expresses that states, the EU as such, should accede to the European Convention on Human Rights, which was the intention of the member states because they signed the Lisbon Treaty. And afterwards, the CGU came up with an opinion that it's not possible to join, in the CGU's opinion, because of the hierarchical relations, and it would be another institution, the European Court of Human Rights, who would interpret the European law. And now there is this question, then how? Because it is a treaty obligation under the Lisbon Treaty, which was, I think, supposedly the will of the member states at that time. And there is no solution for that because the court said that it's because of sort of hierarchical issues, it's not possible. So it was a remark. Maybe.
So I want to point out, let's say, only one aspect, that there are a lot of terms, notions, that are homonymous in the national legal order and the European legal order. Rule of law, fair trial, etc., rights, liberties. And I can give you an example that I had in mind, the notion of full harmonization. For example, when we are speaking about the European arrest warrant, the ECJ used this term. It is a field that was fully harmonized. What does this mean? The reference cases are Meloni and Franson. The ECJ says, as long as I've established that this procedure is according to the fair trial, you, Constitutional Court, cannot give a higher standard of protection. In Meloni, as you know, there was a case of an Italian that was convicted in absentia in Italy, and was caught in Spain, and according to the Spanish procedural rules, such a person had to have another trial. And the ECJ said, no, mutual recognitions between the EU legal orders, so it is according to fair trial. About rule of law, I can tell you that in the mind of the Romanian Constitutional Court, never was that it or the state, the Romanian state, should contravene to this principle. No. Actually, we had decisions, sectorial decisions, but the ECJ felt that all these sectorial decisions made a situation that was threatening to the rule of law. So if you want to learn about the mistakes of the Romanian Constitutional Court, is that first of all you have to see what the ECJ thinks about certain problems, and you do not directly put the questions. So it is against rule of law? No, because this will give rise to a direct confrontation between the two courts if the Constitutional Court would have another orientation. Armin von Bogdandy, in an article, speaks about the German and the Italian model. And when we had the discussion with Armin from Bogdandy, he scared me by a gesture. When he said the German model, he put his hand on the table like the Germans, it's, yes, as the Constitutional Court says, it has to be happen like that. You know, the 5th of May from 2000, that decision. But the Italians are more wise. In Tarico 1, they asked something. The answer was not good for the Italian Constitutional Court about time limitations. And put another question. And it seemed that the answer began to be acceptable for the Italian legal order. So these references, preliminary references, are meant to make a compromise between the two legal orders, because somehow the ECJ feels what the constitutional courts want, and the constitutional court will see the opinion, the decision of the ECJ. Yeah, and everybody has to learn about these mistakes. Enrico said that in 2016 there was a decision of the Constitutional Court of Hungary in which it was an abstract control, yeah, and didn't enter into a concrete, in the concrete issues. Yeah, it was a wise decision, because if you enter into concrete issues and you do not question the opinion of the other side, it will happen, as in Romania, that any court will apply to the ECJ, and the mandatory effect of the Constitutional Court's decision somehow will be overruled by such a decision. So that happened in these 2 or 3 years in our legal order. Thank you.
I would like to ask you then, what would be your opinion? Because I would say that Spain is a better example as a kingdom, because in Catalonia, the ruling party is Republican left. And what if there were, certainly there are, certain scholars, professors in Catalonia, in Barcelona, Valencia, or as a part of Catalan countries, who are on the side of republicanism. And they write in their articles about these notions, about these ideas. Do you consider it as an attack on the Spanish public order, as kind of scientific activity that should be limited, or it is acceptable?
We have to distinguish two different ways of, I would put it, narratives. If professor discusses ways of developing situation in which possible recognition could happen by giving historical examples and what democratically could be done and what are the options, that, in my opinion, should be allowed. But if you have a class where professor gathers students to work actively as activists on demolishing the government, that wouldn't be. Because every country has its foundational principles set up by constitution. Without them, there is no existence of the state. I don't know any state in this world which will be self-destructive and which will allow behavior which would cause demolition or evaporating. So it's not easy to answer, but I would say discussions, yes, political theories, yes, but then you have to have a line. Activism, organization, which would then cause trouble to politics, then you have to go out of university for that. Then you're a political party, and that's something completely different. Do you see where I'm going to? This was just over simplification, maybe. But I just want you to think. I don't have answers for this, guys. You know, really, the truth is that professors don't have answers. Professors only have questions. You will realize that later.
I do have a question for Professor. I know that professors usually, they have questions as well. But I'd like to hear your comment upon the final part of your presentation about the margin of appreciation. Because, in fact, if you compare other regional systems, the Strasbourg system is very specific. So whether you, me personally, I think that the margin of appreciation concept should not have been born within the system, because it's not a real concept. It does not have real rules. And if we talk about rule of law, it has created much more problems than solutions. and sometimes you expect the court to apply it. Sometimes you just hope it won't apply it. So whether you can see any possibility how to get out from this situation, because sometimes it might be even dangerous. For example, the Finci case, as for Bosnia and Herzegovina, it was a very specific situation, and the judgment that was adopted, I think it was.
You mean Sejdic-Finci case? Okay, thank you. All good stuff. I agree with you, Katarina. This is margin of appreciation doctrine is not a rule, but it's widely used, and many judges are really keen to imply. And of course, since this is, I would say, way of maneuvering things, it can, since it's not strictly written as a rule, it can sometimes cause more trouble than benefits. But I would say that using margin of appreciation doctrine actually shows something, that Europe is not ready to get, at least most of judges, as I know their way of thinking, are not ready to get rid of their, I would say, national identities and their local culture. When you look panels of judges from different countries, you see how they opt and they work together. Even the case is not familiar, or they are not familiar with the case they are in charge of, but they can correlate to some specific issues from their own country. No judge is ready to erase national, cultural, historical, I would say, peculiarities. And this is something more as a litmus paper to show that European law is not like a clean slate. But I agree with you, it's not the rule which can be just implied, oh, we are using margin of appreciation, that means that. But I can only have a comment on that. That's all. Thanks.
In your presentation, you refer to a process in the European Union as constitutionalization. And my question is whether this denomination is correct, taking into account that the European Union at this moment is not a state. Therefore, my question, what do you think about this? And that's all. Thanks a lot.
Regarding actually the outcomes of developing so far of the European Union, we shall all agree that, of course, it's not even, we don't have still, about the legal nature of the European Union remains still unanswered. Of course, we all agree it's not an international organization. We can only say it's a kind of international organization, sui generis, but we can only, we can only look and we can only analyze now and look for some developments. When we have so many, we have, of course, common values, common interests, but so many sovereign states. So and European Union we regard as autonomous legal system. So it's really for me it's an kind of still an ever closer union. Let's say like that. But we can say that the only. I can qualify like that. So thank you very much for your question. We are sure, I'm quite sure that we'll never be the state, of course, but having in mind all what is happening right now in the European Union as well. Thank you very much.
I've got a question, Benjamin, because I haven't maybe understood what does it mean to apply more strict standards? Can you give any particular example? Like some of the elements that have already been mentioned today are more focused on, or what does it mean that the Council of Europe, I mean the European Court, has applied more strict standards?
Actually, this goes also the other way around. Actually, sometimes it can be found that actually there are more strict standards regarding rule of law and also human rights implemented within the internal legal system of the Republic of Slovenia, because as we know, this particularly in the area of criminal justice, these human rights standards and rule of law standards at the European level has actually been decreasing lately. At least in the last decade or 2 decades, even they have been decreasing in a sense that certain fundamental rights, such as right to access to a lawyer, for example, and also right to remain silent if somebody is a suspect of a criminal offense, they have been relativized. I will not go into the details of this, but this is the fact, and it's obvious to any criminal justice expert, actually. But my point here, yes, in my presentation was the other way around, that there were cases when constitutional complaints were filed at the Constitutional Court, and the Constitutional Court established that there was no violation of fundamental rights, and these cases were, of course, criminal law cases. And then the individual, the petitioner, lodged a complaint at the European Court of Human Rights, and actually he succeeded with this complaint. Among the cases I mentioned, there is also this Benedict case. It is an interesting case. It was about a person who was a member of a group, an internet group, which was exchanging child pornography. And it was an international case, of course, and Swiss police identified an dynamic IP address. It is a matter that concerns electronic evidence in criminal proceedings. That is another international project I'm working on right now. And Swiss police identified dynamic IP address of the computer which took part within this exchange of these materials. And they realized that it should be in Slovenia, located in Slovenia. And they sent this dynamic IP address to Slovenian authorities, actually to Slovenian police. And Slovenian police, without asking for a court order, they obtained a subscriber data of this user of the computer. And this is how they identified the guy, and then, of course, there was a conviction and everything. And the Slovenian Constitutional Court claimed that there was no justified expectation of privacy in this case, because he was, in an internet group, and so on and so on. But the argumentation of the Strasbourg court was the other way around. They said that in this particular situation, of course, this is about protection of privacy, personal data, and so on. Even though it's only this most basic electronic data, subscribers' data. In such situation, police should ask for a court order to obtain this data. So this is a clear example of how European Court of Human Rights somehow determined a stricter regime regarding human rights protection than Slovenian court. Yeah.
Thank you. So standards are the same, but the way that they are applied in a more stricter way. Because the standards, the application of them is different, not the standards.
At the end of the day, according to Slovenian courts, including Constitutional Court, no court order was needed to obtain this information about the suspect. According to the European Court of Human Rights, a court order was needed, which means a higher standard of procedural rights and guarantees.
I have a question for Professor Šmigova. We were commenting on the recommendations that if they are covering the specific areas, then in those cases they will be found out as directly applicable, as I understood. And you mentioned that the case with murder was the one case that was considered the directly applicable because it was a specific area. But I'm wondering if there are some kind of recommendation or some kind of requirements under which those cases will be considered directly applicable.
I think that recommendations are not legally binding. The decision that was adopted by the Spanish Supreme Court, it was a big surprise for practitioners, for academia. It was like a wake-up call, come on, how could you dare adopt such a decision? And that's why I've said that because it was so specific, it was explained that really the public authorization there were several procedural problems within the Spanish administration when trying to protect the rights of a child and the women's right of mommy. But I don't think, as for the rule of law, that there are any criteria to distinguish. Why I wanted to analyze the decision was that at the beginning, within all those blogs and commentaries, it was pointed out that the national legal order of the Spanish kingdom was so specific. But then I realized it is comparable to the Slovak national legal order, and the decision of our constitutional court is completely different. So you've got the same facts. You've got, well, there are some cases, as I said, at the Slovak national level, but they do not include murder. But the fact, violation of a right that is protected by the convention is there in both cases. The national legal order, as for the relationship between the international law and national law is comparable. Nevertheless, they are completely different decisions. And I think that it was not because of the rule of law and norms, legal norms, but because of the political lobbying, what we can see in relation to the recommendations. I haven't included it here, but as for the Human Rights Committee that was created in relation to ICCPR, there was a proposal of General Recommendation number 33, and for example there, the committee itself proposed that the recommendations, the formulation that was used was not accepted by the state, so at the end of the day it was changed. But as if step by step there were efforts to point out that we should take those recommendations into account much more. But I think that the international treaties that have created these committees and all those authorizations of these committees, they do not provide, if we take into account those rule of law norms, they do not provide the opportunity, the authority for the committees to provide legally binding decisions. That's why the Spanish decision was so surprising for academia, for practitioners, but it is used. It is used as, of course, there is no presidential system in Slovakia, and even the Slovak Constitutional and Supreme Court, although sometimes it refers, I'm looking at you there, because Slovakia, of course, usually looks at the Czech Constitutional and Czech Supreme Court. Nevertheless, they point out that decisions of other courts or committees, whatever, they are not legally binding, but they, if the party, the plaintiff, points out the decision, they have to react to it. So the general approach of the Slovak Constitutional Court and also some decisions of the Supreme Court is just like, no, these are quasi-judicial bodies. These are not judicial bodies. And I tried to find out what might be the difference you are asking for. I haven't found any. And that's why at the end I've pointed out the other decision, that even it sometimes might depend on the composition of the panel of the chamber, that even the Spanish Supreme Court chamber in another decision as if tried to soften its previous judiciary. So I don't think that there are any. But the fact is that this decision has been pointed out and analyzed by many practitioners and academics as well. Sorry, so I don't think there is any. Although some people would like to point out some specificities, but I don't think so personally.